Leaving money to your grandchildren is one of the most loving things you will ever do. It is also one of the worst financial decisions you will ever make. My name is Eric, and this is Retirement Plan with Eric. Today I am walking you through the 4 most dangerous mistakes grandparents make when they try to leave money to their grandkids, plus the smarter, safer alternatives, so your legacy actually reaches them. Because if you make even one of these 4 mistakes, the IRS, the probate court, even your own family can end up taking what you meant for the next generation. But don't worry, by the end of this video, you will know exactly which document fixes all 4. You should never, and I mean never, write a check to a grandchild, sign a deed in their favor, or fill out a beneficiary form with their name on it until you know what I am about to show you. Mistake number 1. A single check to your grandchild, even a $500 birthday envelope, can cost you over $100,000 in nursing home bills the year you fall. Here is how that trap works, and most grandparents never see it coming. According to Genworth's 2024 Cost of Care Survey, the national median for a private room in a nursing home is over $100,000 a year, more than $8,000 a month. Most people cannot pay that out of pocket for very long. So when the savings run out, they apply for Medicaid. And here is where Medicaid plays by a rule book nobody ever showed you. Medicaid is not just based on what you have today. It looks back. According to the Centers for Medicare and Medicaid Services and every single state Medicaid agency, the program runs a 5-year look-back on every transfer of money or property you have made. Every check to a grandchild, every bank transfer, every birthday envelope, every wedding gift, every dollar you helped them with on a car or a tuition bill. Now here is where retirees get tripped up, and I want you to lean in for this one. You probably know about the IRS annual gift limit. For 2025, the IRS confirms that limit is $19,000 per recipient per year, completely tax-free. A lot of grandparents hear that number and they think, as long as I stay under $19,000, I am fine. That is an IRS rule. Medicaid does not care about it. Not even a little. Medicaid plays by completely different rules, and under those rules, even a $500 check to a grandchild can count against you if it was made within that 5-year window. When Medicaid finds gifts inside the look-back, they calculate a penalty by dividing the amount you gave away by the average monthly cost of nursing home care in your state. That penalty is the number of months Medicaid will refuse to pay for your care. Sometimes it is a few months. Sometimes it is more than a year. I have seen families scramble to come up with $8,000 a month because Grandma gave the grandkids $20,000 over the 4 years before she fell. She thought she was under the IRS limit. She thought she was fine. Nobody told her Medicaid plays by completely different rules. Here is the fix. If you want to pass money to your grandchildren and protect yourself from a Medicaid penalty, you cannot just stay under the IRS limit. You need a plan that respects both rule books. Talk to an elder law attorney licensed in your state. This is not a do-it-yourself situation, because the rules vary by state and they change regularly. There are 2 tools that come up often. One is a Medicaid Asset Protection Trust. You move assets out of your personal name into the trust. You can still benefit from them while you are alive. And if it is done early enough, usually more than 5 years before you apply for Medicaid, those assets are shielded when the look-back happens. The second tool is a promissory note. Instead of giving money to a grandchild, you lend it to them, with the right repayment structure written into the document. Done correctly, it is not treated as a gift, and it can move family wealth without triggering Medicaid's penalty. So write this down. $19,000 is the IRS rule. 5 years is the Medicaid rule. They do not talk to each other. Knowing the difference could save you $50,000, $60,000, even $100,000 in nursing home bills you should never have had to pay. Before I move on to mistake number 2, do me one favor. Drop a number in the comments. 1, 2, 3, or 4, for which of these 4 mistakes you are closest to making right now. I am reading every comment, and the one that comes up the most is the one I am doing a full deep dive on next week. And if you want the document that fixes all 4, hit subscribe right now and turn on notifications so you do not miss it. Mistake number 2. Leaving money directly to a minor grandchild. This is the single most common mistake I see, and it is so easy to make. Grandma fills out a beneficiary form on her life insurance policy. She writes, in big block letters, "To my granddaughter, Emily." She feels good about it. She just signed her name to 2 of the worst problems you can create on one piece of paper. Problem 1. Minors cannot legally inherit assets in this country. They are not adults. They cannot sign a contract. They cannot open a brokerage account. So when the check arrives and the beneficiary is a 7-year-old, the court has to step in. A judge appoints what is called a conservator. That means a public legal proceeding, ongoing court oversight, annual reports filed with the probate court, and conservator fees that, according to the National Conference of State Legislatures, often run between 3 and 5% of the assets every single year. Problem 2, and this is the one that wrecks families. The day that grandchild turns 18, or in some states 21, they get every single dollar. All at once. No strings attached. No requirement to use it for school. No protection from a bad relationship. No safeguard if they are struggling with addiction. No mentor. No structure. A bank statement and a debit card. Let me tell you about a man I will call Robert, and I want to be clear up front. This is a composite case, based on the kinds of stories elder law attorneys see every week, not a real person. The dollar amounts are the dollar amounts. Robert had a life insurance policy worth $180,000, and he made his grandson Tyler the beneficiary. Robert assumed Tyler's parents would just hold on to it for him. They had no legal authority to do that. Tyler was a minor. The probate court appointed a conservator. For 3 years, that conservator filed annual reports, charged about $4,500 a year in fees, and was legally required to keep the money in conservative, low-yield accounts. Then Tyler turned 18. The conservator was discharged. Tyler walked into his bank with a court order and walked out with full, unrestricted access to about $161,000 in cash. He bought a brand new Tesla. He built a gaming setup that filled half the apartment. He took 6 of his friends to Cabo for a week. He was effectively broke 14 months later. He never enrolled in community college, which had been Robert's whole reason for leaving him the money. Robert's love showed up as a $180,000 lesson that did nothing for that kid. Here is the fix. Never, ever name a minor as the direct beneficiary of an account. Instead, leave that money in a trust, with the grandchild as the trust's beneficiary. The trust is the named beneficiary on the policy. Inside the trust, you set the rules. You stagger distributions, 1/3 at 25, 1/3 at 30, the rest at 40. You name a trustee, and it does not have to be a parent. It can be a sibling. It can be a professional. You build in protections for health, education, and basic needs, so the trustee can always pay for college tuition or medical care or a first home down payment, but cannot just hand the kid a check for a Tesla. A simple trust with a distribution at age 25 would have completely changed Tyler's life. If you take one thing from this section, take this. Minors and lump sums do not mix. Period. Mistake number 3. Naming a grandchild directly on a retirement account. This is the one that gets people who otherwise have really solid plans. Because once upon a time, this was a fantastic idea. You sat down with your IRA or your 401k beneficiary form. You wrote your grandchild's name on it, and you walked away thinking you had just bought them decades of tax-deferred growth. That used to be true. It is not anymore. In 2019, Congress passed a law called the Secure Act, and the Secure Act blew that strategy completely apart. Before that law, a grandchild could inherit your IRA and stretch the required distributions over their entire lifetime. The IRS confirms that for most non-spouse beneficiaries today, that account has to be emptied within 10 years of your death. 10 years, that is it. For a grandchild in their 20s or 30s, that 10-year window often lines up exactly with their highest earning years, when they are building a career, when they are buying a first house, when their tax bracket is climbing. Forced distributions out of a traditional IRA get added on top of their wages. That can push them into a higher tax bracket. The IRS takes a much bigger bite than you ever planned for. The grandchild ends up with maybe 60 cents on the dollar of what you thought you were leaving them. Let me show you what that looks like with real numbers. And again, this is a composite case. The kind of story elder law attorneys see every week, not a specific person. Picture Linda, age 72, with $400,000 in a traditional IRA. She names her grandson Jordan directly on the beneficiary form. Jordan is 28, a software engineer earning $90,000 a year. Linda passes a few years later. Under the Secure Act, Jordan has 10 years to empty that account. To stay on track, he pulls about $40,000 a year. According to the IRS, the 24% federal tax bracket kicks in for single filers at roughly $103,000 of taxable income in 2025. Jordan's $90,000 salary plus $40,000 in forced distributions puts him right in that bracket. And in many states, another 5 to 9% on top in state income tax. Over 10 years, the IRS and his state government collectively take well over $100,000 of what Linda left him. Jordan inherits about $270,000 net instead of the $400,000 Linda thought she was leaving him. Same IRA, same grandchild. Over $100,000 vaporized to taxes Linda never had to trigger. Now let me show you the same IRA with one move. Linda spends her 60s, those low-income years between when she retires and when Social Security and required minimum distributions begin, converting $20,000 to $30,000 a year from her traditional IRA into a Roth IRA. She pays the tax at her bracket, which is much lower in retirement. By the time she passes, more than half of that IRA is sitting in a Roth. Jordan still has to empty it inside 10 years, but he pays zero income tax on the Roth portion. That single decision can shift another $50,000 to $70,000 from the IRS's pocket back into Jordan's. Here is the fix. First, do not name the grandchild directly. Name a properly drafted trust as the beneficiary, with the grandchild as the trust's beneficiary. This gives you control over the timing and the taxation. The trustee can stretch withdrawals across the 10 years to flatten the tax hit, instead of crushing them with one big distribution at the end. Second, and this is the move the wealthiest families have been making quietly for years, talk to your tax preparer about partial Roth conversions during your low-income years, particularly the window between when you retire and when Social Security and required minimum distributions start. You pay the tax now at your rate while you are in the low brackets. Your grandchildren inherit a Roth account. According to the IRS, qualified Roth distributions are tax-free. They still have to empty it inside 10 years, but they pay zero income tax on the distributions. You can move $5,000, $10,000, $20,000 a year through Roth conversions in your 60s and turn a future tax bomb into a future tax-free inheritance. The Secure Act killed the stretch. It did not kill smart planning. But it did make naming a grandchild directly on your IRA one of the most expensive habits you can keep. Mistake number 4. Giving your house to your grandchild while you are still alive. This one comes from such a good place. You have worked your entire adult life to pay off that house. You want it to stay in the family. You want to skip probate. So one afternoon you walk into a title office, or your nephew, the real estate guy, comes over with a quit-claim deed, and you add your grandchild's name to the deed right then and there. Simple. Clean. Done. That single signature can cost your grandchild tens of thousands of dollars in taxes that the IRS itself confirms did not have to exist. Here is what happens. When you give someone property while you are alive, the IRS says they inherit your cost basis. According to IRS Publication 551, the basis of assets received by gift is generally the same as the donor's adjusted basis in the property. That is the price you originally paid for the home, plus the improvements you made over the years. Now let me show you what that means with real numbers. Let me tell you about Dorothy. She bought her home in 1979 for $65,000. She made about $20,000 of improvements over the years: new roof, a kitchen renovation, a deck. Her cost basis is about $85,000. She wants to leave the house to her grandson, Marcus. The neighbor tells her to just put Marcus on the deed now to skip probate. She does it. A few years later, Dorothy passes away. The house is worth $390,000. Marcus decides to sell. Because Dorothy added him to the deed while she was alive, Marcus's cost basis is Dorothy's cost basis, $85,000. He sells for $390,000. That is a gain of $305,000. At the long-term capital gains rate, the IRS takes around 15% of that, which is over $45,000 out of Marcus's pocket. Now let me show you the same exact story with one change. Instead of putting Marcus on the deed, Dorothy puts the house in a revocable living trust, with Marcus as the beneficiary. She keeps full control of the house her entire life. The day she passes, the house transfers automatically to Marcus, no probate. And here is the magic. According to IRS Publication 551, property received from a decedent gets what is called a stepped-up basis. Marcus's cost basis is reset to the fair market value on the day Dorothy died, $390,000. He turns around and sells the house the next month for $390,000. The gain is zero. The capital gains tax is zero. Same house, same grandchild, same end result. One piece of paper made a $45,000 difference. So here is the fix, and I want you to hear me clearly. Do not deed your house to your grandchild while you are alive. The tax consequences almost always outweigh the convenience of skipping probate. Instead, leave the home through a revocable living trust. You stay in control while you are alive. It transfers to your grandchild the moment you pass. Probate gets skipped. Capital gains tax gets minimized. And the wealth you spent 40 years building actually reaches the next generation. Talk to an estate planning attorney before you sign any deed, especially before you sign a quitclaim deed your nephew, the real estate guy, brought over on a Sunday afternoon. Now, before I let you go, I want to leave you with one more thing. Because all 4 of these mistakes have something in common. They all happen when assets transfer with no structure around them. A check, a beneficiary form, a deed, a piece of paper signed at the kitchen table with no plan around it. The solution for almost every single one of these is the same: a trust. A trust controls timing. You decide when the grandchildren get the money. You can tie it to milestones: graduating from college, buying a first home, launching a business. Or you can stagger it across ages: 1/3 at 25, 1/3 at 30, the rest at 40. You stay in charge even after you are gone. A trust protects assets. A properly structured asset protection trust shields the inheritance from creditors, from lawsuits, from divorces. Your grandchild can get sued, can get divorced, can lose a business, and the assets inside the trust are generally out of reach. A trust stays private. Trust distributions do not go through probate court. They never become part of the public record. Nobody can look up what you left or who got what. A trust builds a wise adult. You choose the trustee, a sibling, a professional fiduciary, a corporate trustee at a bank. Your grandchild gets a built-in financial mentor, whether they want one or not. And here is something the wealthiest families do that almost nobody talks about. They pair their trust with a letter of wishes. That is a personal letter to the trustee that describes your values, your judgment, what you would have wanted them to do in a tough situation. It is not legally binding. But when your grandchild is 26 years old and walks in asking for $100,000 for a half-baked business idea, the trustee can pull out your letter and say, "Your grandmother left this for me, and she did not want me to fund anything without a business plan and a co-investor." That is the kind of voice that protects a grandchild from themselves at exactly the moment a lump sum check could not. So let me tie this together with one action plan. 1. Stop writing direct checks to grandchildren in your 60s if there is any chance you will need long-term care in the next 5 years. Talk to an elder law attorney about a Medicaid asset protection trust or a promissory note structure. 2. Go to every account that has a beneficiary form, life insurance, brokerage, IRA, 401k, and make sure no minor grandchild is listed directly. If they are, change the beneficiary to a properly drafted trust. 3. Ask your tax preparer about Roth conversions during your low-income years before required minimum distributions start to turn a future Secure Act tax bomb into a tax-free inheritance. 4. Do not deed your house to a grandchild while you are alive. Talk to an estate planning attorney about a revocable living trust so the stepped-up basis is preserved when the home transfers. And 5. Write a letter of wishes to whoever your trustee will be. 1 page, plain English. Your values, your judgment, what you would have wanted. It will outlive you, and it will protect your grandchild on the worst day of their financial life. Setting up your grandchildren financially is one of the most beautiful things you will ever do. But love without structure becomes someone else's headache. The IRS gets a bonus. The probate court gets a project. Your family gets an argument. The grandparents who get this right do not love their grandchildren more than the ones who get it wrong. They just planned earlier, and they used the right document. Take action on what you learned today, and you are already miles ahead of the average estate plan. If this video helped, hit the like button. That tells YouTube to push it to more grandparents who need to hear it. Subscribe and turn on notifications so you do not miss the deep dive next week on whichever mistake you tell me in the comments scared you the most. I will see you in the next one.